is Lie Uema do Carmo. I'm a business law professor at FGV Direito São Paulo, and I have the honor of having here with me now, and actually the law school had the honor of having Professor Matthias Storme teaching here for a whole week. And thank you very much, Professor.
It was a pleasure.
It is a pleasure. I guess I would like to introduce you briefly with just one very short presentation. Professor Matthias, he teaches private law and comparative law at University of Leuven and also at University of Antwerp. And he had the honor of sharing his thoughts and lessons with us here in São Paulo for the past week. So, Professor, for the sake and the benefit of all of us, I would like you to, first of all, before shooting questions, I'd like you to introduce yourself a little bit further.
Well, I was born in Ghent from a family of lawyers, well, at least for 2 more generations. Before that, there were not so many lawyers in the family. So my father was a law professor, actually, also, who has also been teaching in Brazil, by the way. I studied law at first the Jesuit College in Antwerp and then at the Catholic University in Leuven. I studied philosophy in Leuven and in Yale in the United States. And then I went to Bologna and to the Max Planck Institute in Hamburg to continue working on my PhD, which I finished in Leuven in 1989, and my doctor father was Professor van Gerven, who outside Belgium was better known as Advocate General at the European Court of Justice, but for us he was mostly known as a great law professor who has written some classics, so to say. Yes. I've been practicing law to some extent afterwards, but I became a professor in Antwerp part-time and in Amsterdam for a few years, and then finally full-time in Leuven. So I'm teaching mainly insolvency law, international business transactions, some real estate law, and comparative law methodology, and some legal theory.
Oh, wonderful, Professor. Can you, for the records, tell us a little bit what were the interesting topics that you've been sharing with the FGV students this week?
Well, I don't know if they were all as interesting because they would evidently wanted to make a course which is a little bit consistent. It is dealing with European and comparative contract law. It deals with most of the classic topics of contract law, but also some less classic topics. And I'm trying to do it not from a national perspective, but taking into account the differences between, mainly the legal systems within the European Union, because that's already enough, and evidently most, let's say, legal systems in the Americas developed from a kind of mother system in one of the European countries, whether it is England or Portugal or France. I've tried to develop for the students the complex questions that arise out of the fact that we have this very special federal system with European law and national law and how they have to be combined, but not so much on the theoretical level, but applying these questions to concrete questions of contract law. And especially in the field of consumer law, you see that. I've always also trying to compare national and European contract law with international instruments, especially for Brazilian students. Since Brazil has ratified the Vienna Convention a few years ago, it was interesting to compare with sales law in the Vienna Convention and some soft law instruments, unit droit principles for international commercial contracts, because they are the most interesting, although I know better the principles of European contract law because I was part of the group drafting them. I was not part of the unit work group. So these are things that were developed, and in the last part of the class I'm tackling one of my favorite topics in contract law, which has to do with more complex questions of multi-party relationships. Because classical handbooks, they do as if most contracts are two parties, but these contracts between two parties are in many cases just part of a much wider network of contract supply chains. I have a colleague who always says, you know, the average contract is part of a network of 72 contracts. I don't know where he gets the number of 72, but it gives you at least an impression that you shouldn't look at the contract in isolation. So that's one of the messages in my class. Yes.
Oh, wonderful. Professor, one of my interests is complex theory, and especially in contract law, which is a new field. So talking about a network of contracts, and especially thinking that a significant part of this network of contract, let's say about large construction, large engineering contracts where you have a dam being built in the Amazon, and the insurance and the reinsurance agreement. So, and there's a number of subcontracting, a number of sale of good contracts. There's a very large network of contracts which are working in several, sometimes legal systems with multiple parties. What do you think that nowadays is a challenge for this type of contract structure, or challenges that you're currently seeing in the EU context?
Probably most of the challenges are not of a legal nature. They have to do with political, economic situations, scarce resources, environmental law, and other movements. But it is for the law to take these things into account. That's a challenge for every generation, evidently, of lawyers to try to make the law fit for the challenges of the time. Many challenges are, let's say, for many centuries, you have the classical problems of contract law are still actual today. The balance between freedom of contract and protecting weaker parties and protecting other values, etc. But some of them are probably more urgent than others. We are now in Europe, we have quite a lot of debate, and we're also trying to do something about it to make also the rules of contract law more sustainable, to use a very fashionable word, which is not a very clear word, but most people know what's meant by it. And also in the topics that I was discussing in class with the students, in consumer law, for example, how do we make rules so that people are using more care, consuming less, or at least making it possible to reuse or recycle more. And we see that some rules of consumer protection have had precisely the opposite effect. You can buy things online and send things back many times. We all understand where these rules come from and why they're there, but it's time to rethink them. Now that's a consumer law example. Evidently, same questions can be asked for business contracts in whether in supply chains or in big projects. And that is certainly an important challenge of our time. But the technique is one doesn't have to be, let's say, a specialist in law and economics to understand that it's important for legislators to make rules by which, as the law and economics people would say, external costs are internalized. And that's a permanent task also for contract law. And we haven't devoted enough attention to that, I think. So that's just one possible answer. There are evidently also other interesting things, but I'll let you ask the next question first.
Would you say that the ESG movement, right, this whole idea of thinking about environmental, social, economic values of a particular society, that they can be also embedded not only from a legislative perspective in contract law, but also in the interpretation of business contracts?
Yes, but when we speak about the movement, there are many elements in it, and well, not everything is as important or as useful, and we still have to find our way, basically. And we see there are, let's say, a number of trials everywhere in the world, and to some extent, evidently, these trials will be addressed to, according to the deepest pocket rule, when trial is addressed against the companies who are the richest, so to say, and they're not necessarily the worst. So there is a danger in this respect, and we have to take care that we concentrate on where we really can make the difference, which may be evidently there because they're the most powerful, but also continue to how to say to make accountable everyone to some extent, not just the selected players, and sometimes it looks like today it's a kind of game where mainly the lawyers themselves are winning, and that's something we have to avoid. Evidently, it is to some extent also driven by private interests, and not necessarily only by the general interest, which means that it is necessary for legislators to look very well how to organize this and how to make the responsibility for everyone who is causing external effects proportionate. I would like to say. It's a difficult topic to summarize in a few sentences.
Absolutely, right. Sometimes we also enjoy the benefits of positive externalities, right? But of course, you're talking about the negative ones. I've heard some economists were in basically, this is the last day of April of 2022, and some economists are saying that globalization is over. Some in the business world also say that we're living really unique times in terms of a number of uncertainties in markets in general and in business in general, where we have high inflation in so many countries in the world, in some a very high level of unemployment, inflation in its turn hitting an increasing inequality, sometimes hitting poor countries and the poor layers of population more, and also a big disruption in supply chains, which is interesting. Common would be the demand side, but now we're in the supply side as well. And that leads us to a long-standing question in law about hardship in contracts.
Yes. Well, what the general background is, evidently, it's always difficult to predict anything, especially the future. But as to globalization, we've seen in the past several disruptions. For a long period, the world has been less global than it was in the early 20th century. It's only much later that it became more globalized than it was before 1914, in a certain sense. But indeed, in contract law, the question of hardship and change of circumstances has become more important because of the pandemic, especially the war in Ukraine, and some other developments. That is sure. What we see is that on the field of legislation and case law, European legal systems are trying to manage, but searching their way. We see that very well as to the effects of the pandemic on contracts. And a very typical example, because there are not so many examples where it is clear that the existing law is not fit. It's a question of evidently distributing risks. But a typical example, which is typical for the pandemic, is the question whether businesses that had to close have to pay the full rent of their premises if they were not able to use them. And until now, we see that the answer in different countries is quite different. That the Dutch and the German Supreme Court, for example, have given different answers. So it shows there's no unitary response for the moment. There is a tendency to accept some form of, let's say, hardship in contract law in general, but when it comes to applying it and to filling it in and to see under which circumstances it is accepted, it's much less clear. And that is one of the problems, evidently, of uniform law. If you have relatively vague norms, there is always a big danger that every country is going to apply them differently. But even within a single country, with vague norms, and they are useful and important, and I made my PhD on the concept of good faith, so evidently I'm not against this, but there is always the risk that also individual judges are going to apply it differently, and how are you guaranteeing also the equality before the law if the margin of appreciation of judges is becoming bigger. And with hardship, we also see this eternal problem coming up again. So that's only a very partial answer, because these developments, like the pandemic and the war, will evidently have other effects. Inflation will lead to certain new disparities, that is true. Although inflation in itself is not such a big challenge from a legal point of view, because we've had such important levels of inflation after the first oil crisis in 73 and so on, that the instruments are there and they're still there. And in our civil codes and our legislation, provisions for high inflation are already there since 30 years, and they have always been used. And for some years we didn't have to use them at all, but they're already internalized in a certain sense. So that in itself will probably not change a lot, the inflation, but the pandemic a little bit more, yes.
In this scenario of geopolitical instability, of businesses having to deal in a more intense way with the unpredictability of effects in their production and their ability to deliver on time, would you expect any change in the way that businesses handle, for instance, the choice between spot contracts or long-term agreements, now that we cannot predict the future, that humankind finally realize how hard it is?
I don't know this. What I have seen very recently in my own region is that, at least in what the businesses say that they are going to do, just in time is over.
Right.
They absolutely want to have stocks again, because they see that they otherwise can't cope and can't perform their obligations, or at least the contracts that they want to do. So and they are, in this respect, they are trying to reorganize themselves to some extent, for certain sectors, the level of globalization will certainly be going down because it's creating much larger risks. It's cheaper, evidently, otherwise they wouldn't have done that. But to some extent, they're returning. Evidently, globalization is not over. The international supply chains will remain there, but probably to a lesser extent than with indeed probably a bit more local content, etc. But that's now in the short term for the next years. That's not a very big prediction, evidently, to say that. Right. As to whether they buy on the spot or with long-term contracts, I have no clear idea about this, because I guess it varies quite a lot depending on which business you're talking about.
Mm-hmm.
Yeah.
We're here at the earning seasons. So, for instance, in the US market and some of the European markets, they're looking into different guidance for this year and for next year. And thinking about guidance, the current economic scenario, and thinking about innovation, I'd like to ask you, what do you think are the new trends for contract law, given the reality, the current reality? What do you envision with the new problems, perhaps, in contract law?
Well, people have been talking for a number of years about, as a consequence of technological advances, to some extent, disintermediation. That in certain businesses, the number of intermediate levels is going down because the technology allows you to sell and buy more directly, etc. I don't think that's something which is true for every sector, and it has given rise to new questions. In consumer protection, for example, sorry to go back to the simple things, but in consumer protection, the fact that just a very practical example, consumers are buying their holidays online, etc. And the whole system of consumer protection that was built around the fact that consumers were going to a travel agency who would put together a package was falling apart, because the consumers were no longer protected by these rules because it didn't fit the model anymore. So also in this respect, lawyers had to rethink how to organize protective rules. European Union has issued a few years ago, for the first time, I would say, stricter rules on contract terms in supply chains, but only in the food supply chain. Now, you could say it's not really on contract law, it's rather fighting unfair trade practices. Yes, but it's basically unfair trade practices in the contractual negotiations that they are fighting in order to protect mainly the small suppliers. The agricultural sector, with many small suppliers fighting against the big companies who are buying the products. So these things have been going on for a number of years, and they will become even more important in the next years, I think.
Here in Brazil, where we have the very important agribusiness sector, really large Brazilian entities are the cooperatives. They're really large, and they were organized as very much inspired in the EU models, so as to be able to buy, let's say, fertilizers, seeds, yes, and whatever they need, and have a rebalance of their bargain power. And they became really large because now they do the inflow and the outflow of the inputs and outputs that are needed in the sector. So they became really large, and they also, of course, sell the production.
Well, yeah, sorry, your question first.
No, go ahead.
But two completely different things I'm thinking about. First of all, historical. Unfortunately, we've seen the importance of cooperatives going down in many countries in Europe in the course of the last 100 years, so to say. It was a movement that started in the late 19th century in many fields, okay, on a very local level, but creating buying power and selling power to some extent, certainly. And there have always been tendencies trying to revive, but in many countries not very successful, with one big exception, which is Switzerland. Switzerland is really a country of, let's say, democratic shareholdership through cooperatives. The two biggest supermarket chains in Switzerland are cooperatives, and every Swiss household has a share in it. And these people, they go to the General Assembly of Shareholders and they are discussing also, for example, the environmental policy of the cooperative company and so on. So you have it also explains to some extent, it goes together with the Swiss character, and politically I'm always very much in admiration for the Swiss political model, because it's so much rooted in a democracy which is based on participation of very large part of the population, also economically, which is strange because Switzerland is also evidently the country of very powerful multinational companies, but it's balanced with these elements. And the cooperative movement is an important factor in this respect, but it goes together with a system of direct democracy. It's the same spirit. And we're missing that in large parts of the European Union, yes, unfortunately. That's one thing. The other thing is that, what was I going to say? In contract law theory, and also in political debates, there is the question whether we have indeed not concentrated or efforts not too much on direct regulation of contracts, behavior, etc., and whether we have not underestimated the importance of organizing, let's say, governance structures, of creating collective action also in the field of supply chains, as we have done with the labor market, basically, at different degrees. And it's always necessary to find a balance, but a large part of labor law is created in many European countries on the basis of negotiations between trade unions and employers' unions, which, by the way, has also the danger that they do not take into account the external costs that they cause. And so they're so much limited to their own bilateral interests that is probably not sufficient. But on a larger scale, not only consumer organizations, but on a larger level of trying to install governance structures to rebalance this relationship is at least something we should think more about, even if I do not think that it is a miracle solution. Certainly not. But it is an element that certainly can be taken into account when we discuss complexity of contracts. Yes. So these two things.
Or welfare, right? Or the social costs of actions and
yes,
legal decisions.
Well, that related to contracts, one of the topics in my class, but I did not really develop this very thoroughly, but I drew the attention of the students to a very special part of contract law in European Union contract law, which has to do with services of general interest. Now, most of these services of general interest, telecommunication, postal services, gas, water, electricity, public transport, etc., were state monopolies. And evidently, the European law was developed by breaking these state monopolies, because evidently they were hindering the common market. If you have state monopolies in every member state, you have no common market. And so they had to be replaced by privatized players. They can still be state-owned, but without the monopoly. And then you have to regulate this. You have to guarantee universal access of every citizen. And it's a whole branch of law came. And this has given rise to kind of mixed public law, private law, contract law. But we also see, from another point of view, that, and this is not neoliberalism, this is just trial and error, that in the traditionally most progressive countries like the Scandinavian countries, we see a kind of greater share of activity that is also given to private business in the welfare sector, organizing welfare. And you get a new mix between private and public initiative in the Scandinavian countries, even in that field, which is considered to be really purely public law, more than telecommunications or postal services, evidently. So I'm quite interested to see how this developed. I must say, one of the reasons why I'm trying to keep up with very different developments in my field of law is because we founded in 1992 with some young lawyers and some old folks together, European Review of Private Law, which is officially trilingual but mostly English. As editor-in-chief, we receive, well, I'm not going to say hundreds, but quite a number of manuscripts every year, and it really gives us an idea of what young lawyers are taking up and which topics they're busy, and they're coming from all countries over Europe, very different style, very different perspectives they use, but having to read and evaluate all these manuscripts gives you quite a good overview of what's happening in Europe.
Awesome, Professor. Can you name a few ideas or avenues that a contract law may be worked in the near future based on these current concerns or interests?
I think the most important we already mentioned in our conversation, on rebalancing supply chains, on sustainability, better use of scarce resources, more environmental friendly contract law, a law that is better weaponed against future crises like the pandemic, inflation. We more or less know how to deal with it. Yes, these things are certainly the case. And then, especially in the European Union, we have to question how far we have to go in harmonizing the law. The system we now have has some clear disadvantages, because we have a system where, let's say, contract law is in principle national law, but the European Union is in a fragmentary way imposing. Well, it's the member states evidently who decide, but from in a legal perspective, from top down, imposing a number of rules. And the way that the European Court of Justice has interpreted European law in general gives rise to difficult problems of transplantation. Mm-hmm. And if I may go back to legal history to make an analogy, in the old jus commune, there was the idea, okay, you have local law and you have the Roman law as a common learned law. And there were these rules of interpretation saying statutes, and statutes was local law, have to interpret it strictly in order to give room to the Roman law as a common law. But the Roman law was the general law, where the general principles and the general rules that apply very broadly horizontally, and local law could deviate from that, but was interpreted narrowly. And so the law that had priority, local law had priority over Roman law, but it was interpreted narrowly. Now in the European Union we have the problem that the law which has priority, namely European Union law, is interpreted largely by the European Court of Justice. And there's, in some cases, this is going wrong, and evidently when they decide certain things, that the fact that there is a certain European rule requires the rest of national law to adapt itself to that rule, is in many cases it's understandable, but it creates huge disparities within national law. If, for example, the Court of Justice says that in order to make rules of consumer protection function, the judge has to apply them automatically, which in many countries goes against the rules of civil procedure, that arbitral awards are not final if the arbitrators have not taken into account consumer law, that you can just restart, that there is no res judicata. This is exploding traditional categories, and probably we have to also find a new balance there. I have at some point defended the idea, which is a crazy idea, but that we should do the opposite, namely have a European civil code and then allow national governments to make exceptions to it. Now we're doing exactly the opposite. We have national legal codes, and then we allow the European Union to make exceptions to it and interpret them widely. Now it's maybe in part a very theoretical point. If you're not busy with these questions, it's like a quite difficult and strange debate maybe. But in the field, and have been involved in these, let's say, harmonization projects for many years, starting with having been invited by Orlando to join his commission when I was still a very young lawyer. In a certain sense, I was the youngest member, so he's one of my heroes, evidently, in the legal world. In the legal world, and then continuing with the further developments with Christian van Baar, whom we will celebrate on the 20th of May for his retirement. I've, especially for me, intellectually, it was the most important thing. Was not so much that I've been contributing to anything, but that I have learned a lot, that I became probably a much better comparative lawyer by taking part and listening to all these great colleagues and see how they were much better in drafting law than we ever learned in our law school. In my country, we are very bad in drafting laws. For example, the statutes are horribly written in many respects. I'm sure we're not the only country. But,
I guarantee.
So, well, that's maybe a message to students, I think, to be a very good lawyer. If you also have some academic ambitions, I think it's important to really try to go quite deep into comparative law, and not on everything, because that's impossible. Life is too short for that. But try to read some comparative law works that are really tackling questions on different levels. And not just on a superficial level. Those are probably the most rewarding things to learn if you have some academic ambition as a lawyer. Probably also for practitioners who have some ambition in international practice, because then you have to understand evidently how other lawyers reason. You can learn that from practice also, that's true, but if you're already prepared by a good study of comparative law, you have already an advantage, I think.
Absolutely, Professor. We've been lately in Brazil, having a number of litigation in M&A, and that's part of a significant part of our arbitral courts in Brazil. And part of the issues at stake is how do we cope with a number of concepts, of institutes, of ideas, of rationales that were brought by the practitioners by importing drafts or the whole structure of an agreement, yes, which wasn't ours. And all of a sudden we're trying to make sense and give a proper interpretation of that within our own civil code and the, I would say, special business usages within the M&A interpretive community.
With some experience in Belgium, I'm not saying we're doing the most interesting things, but certainly in practice, because Brussels is an important hub for international, not so much for international litigation, because our courts are not enough well organized for that. That's clear. Arbitration, yes, but we're not an important country as a seat of arbitration. We're an important country for delivering arbitrators, but not as a seat of arbitration. People prefer Switzerland, for example, for very understandable reasons. And on the on academic level, we're doing some interesting work there. But a country which is amazingly good in this is Italy. Precisely because the Italians at some point became aware of the fact that they were no longer considered to be a big country by the others, and that they needed to have an advantage by studying this. And Italians are, sorry to say, Italian lawyers in academic are much more open-minded than the French or the English or the Germans, I think. And they have paid attention more than in other countries to issues of translatability and in the wide sense, not only language, also.
Right.
If you want to read legal texts on legal translation, the country where you find most is Italy. But also on understanding different mentalities and how to translate them into each other. They're really interesting things in comparative law in Italy going on that luckily have also influenced others in other countries, yes.
For instance, there's a book by Professor De Nova about SPA, where he's trying to get the rationale of the SPA and make sense of clauses and ideas and instruments, yes, under Italian law. And
I'm just going to publish normally soon an article where I'm tracing back the history of the notion of a common core, which is a very ambiguous notion because mostly the result is nothing to do with the common core. Comparative law is not only looking for similarities, but looking for differences, evidently, and trying to understand them. But the intellectual history of this movement is a quite strange combination, mainly of continental lawyers who had an experience in the United States. Schlesinger, Ernst Rabel, Gino Gorla, to name the three fathers, in my view. And then after Gino Gorla, to some extent Rodolfo Sacco, although he did not study in the United States and was not so well in English, but he developed these ideas further and became also quite influential in comparative law. But it was the confrontation of, let's say, citizen European lawyers with a very German Gründlichkeit background in legal history and already comparing law at a certain level with a more empirical American tradition. And this confrontation has given rise to new ideas and new developments that I'm trying to describe in my article that normally will be published later this year.
Well, Professor, looking forward to reading your article. Thinking about legal transplants, frictions, harmonizations of national laws. In comparative law, all that brings me to, unfortunately, our last question, which would be, which books, articles would you recommend for a Brazilian student who's looking to learn more about, have a better view, a better grasp of EU law in your areas of study?
Well, I can give a quite practical answer in the sense that it's an answer that is useful for a larger group of students. For every single student depending on his particular interests, I could give a better answer.
Right, absolutely.
More specifically. Well, that should be a very good there for you. But if you want to give an answer that is useful for a larger group of students, I think there is quite some good comparative work, usually collective, sometimes individual, that has been published in recent decades. Well, going back to Italy, the whole series of the books from the Trento Common Core project, which has the misleading name Common Core because it's stressing differences as much as similarities. But the whole series of the Common Core project contains very interesting material in contract law, in property law, in tort law, mainly in these three fields. It started with the very first book on the use of the notion of good faith in the different member states of the European Union and a few non-European countries also involved, and then some 20 or 25 volumes already. Then I must name, because it's useful in this context, I'm not saying that it's so fantastic in all respects, but my doctor father, Professor van Gerven, he started in Maastricht this series of case books, Jus Commune case books. And they contain a lot of original materials from the different member states that they try to combine to show to what extent there is common ground. And you have a case book on contract, on tort law, on consumer protection, on discrimination law, on antitrust law, etc. For the use that you were addressing in your question, I think they are very useful on this level. They're also collective works. And when I was thinking about recent individual work, well, we have a guest professor in Leuven from Switzerland, and he's really good. It's Thomas Cadner-Graziano, and he has written 2 course books, but they're really intended to be used as class materials on comparative tort law and on comparative contract law. And also he's using a lot of original materials from the different countries. The only thing which is always difficult is that ideally you should be able to have these materials in the original language. Yes. And some of these projects will contain the text with translation, or to be very modern, they will put the original sources online so that you can compare. And I think it's important. Maybe the preliminary question before you say what you have to read. The preliminary question is maybe which languages can you read?
Right.
Not speak necessarily, but just read. Now, I would say, fortunately for Portuguese, for Lusophone people, probably not too difficult to read texts in French and Spanish and Italian, with some exercise, I guess. That's already quite a lot. That evidently determines your horizon, what you're able to, and you detect things that you don't see in translation. Okay, I remember when I was studying philosophy, evidently then we are speaking about classics, and classics, that's a different level. And when you have classics, you very often have important classics in bilingual editions. You have the whole classical library with an English or a German translation next to it. But I remember I was studying in Yale philosophy, and people were reading German philosophers in English translation. And I had the German original with me. I could always say in class, well, you're discussing this, but that's how it is in the original language. Take that into account. If you only have the translation, you can understand it falsely. And in comparative law, it's a bit the same thing, evidently. But okay, now I'm talking about, let's say, a very advanced level of knowledge. If you really want to dig in a specific topic, that is not, let's say, the basic level of a good academic knowledge in general. Yeah, but it's certainly something that we should stimulate with the students.
Absolutely, and I think that nowadays revive the importance of true comparative exercise and broad understanding of comparative law.
Our students are obliged to take at least 2 courses in another language, and in principle even in 2 different languages, apart from our language being Dutch. So every student from our law school will have had at least 1 course in English, and normally they should have had 1 course in French also. Yeah.
Awesome. Professor, I think that perhaps the last question, actually. How about what you do, because you have a very broad production and you have interest in a number of different areas of law, insolvency. You're actually an explorer of the wide range of what we call private law. But my question would be, what do you do to get the creativity?
Yeah, not everything in private law. I know nearly nothing about corporate law, which is your field. I leave that to my daughter. she must be able to find something where she knows things that her father doesn't know. But I've been writing quite a lot in civil procedure, because my father was in civil procedure, and combining it with national law, with substantive law in contracts, and in insolvency law, in property law. Because of, let's say, political interests, I've always had some interest in constitutional law. As a practical lawyer, I've been pleading quite a number of cases before the Constitutional Court, which is quite interesting, because it's purely a question of law that you're discussing, but evidently you have to try to give the social and economic background, but formally speaking, you're not discussing any facts. So the link with some questions of constitutional law is certainly interesting if you discuss the influence of European law and the position of the judge and the advantages and dangers of judge-made law, which is something which occupies me quite a lot, I must say. But I have, since a number of years, I've tried to oblige myself to tackle every year something outside of my comfort zone. Usually it's by just promising to deliver something at a conference about which I do not know many things, and then study it. So I okay. If you have a general cultural background, you can combine things. There was, for example, I contributed to a book about Edmund Burke. But I wrote a chapter, Edmund Burke as a lawyer, in a certain sense, or legal philosophy that you can detect from that. And then the next year we had a conference on the Federalist Papers, where I discussed the anti-Federalists, because everybody reads the Federalist Papers, but I wanted to see what were the arguments against it, and what happened with these arguments, who was right and who was wrong in the long run, not in the short run, in the long run, seeing what happens today, for example, in the European Union and so on. I have promised to deliver a lecture in September on von Humboldt, which will create some difficulties for my summer holidays because it's more tough than I expected. I think it's a good thing to try to oblige yourself to do something outside of your comfort zone, and then evidently try to link back and find new combinations of ideas, interdependencies between things that you wouldn't have seen otherwise. It's also it's a bit in the same line. I started to look different at my own legal system by being obliged to teach Dutch law in the Netherlands. So I had to, it was the year that the new civil code entered into force. And so I said to my colleague, but you obliged me to teach Dutch law, but I don't know anything. And he said, we neither, because it's a new civil code that we're going to teach for the first time. So we all have to study this year. I said, okay,
no
then
experts,
it's good.
Right?
Then it's good. And then, because then you're going much deeper into another legal system, and you say, we always explain this differently, but we do exactly the same. And we try to explain it in a way that has never convinced me. Now I see that there are other ways to explain this, and it's much simpler in another way. And so you're going to use a different perspective to look at your own legal system. And that is also quite interesting, yes.
Professor, thank you very much. You've certainly have left an important mark here at the law school, and now with this, the pleasure of this interview, we had the chance of learning important lessons of and parts of your career and lessons that you've learned. So thanks for the generosity of sharing that.
And thank you for first giving me the opportunity to teach here, which is evidently something very important for me. And then also this interview, because in such an interview, you know, in the end, you are saying things that you've never said before. By reflecting in a dialogue, you come to new ideas yourself that are probably worth developing further at some other occasion.
Well, thank you very much. And this, I think that's part of our law school, the Global League program. And
yes,
thank you very much. This was very enriching.
Obrigado.
Thank you. Obrigada.